Protocol of 2005 to the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation. Signed in London on 14 October 2005, entry into force, in accordance with Article 18 of the Protocol. Depository, Secretary-General of the International Maritime Organization. Preamble. The states parties to this protocol, being parties to the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation done at Rome on 10 March 1988, acknowledging that terrorist acts threaten international peace and security. Mindful of Resolution 8.924/22, of the Assembly of the International Maritime Organization requesting the revision of existing international legal and technical measures and the consideration of new measures in order to prevent and suppress terrorism against ships and to improve security aboard and ashore, and thereby to reduce the risks to passengers, crews and port personnel on board ships and in port areas and to vessels and their cargoes. Conscious of the Declaration on Measures to Eliminate International Terrorism, annexed to United Nations General Assembly Resolution 4960 of 9 December 1994, in which, inter alia, the states members of the United Nations solemnly reaffirm their unequivocal condemnation of all acts, methods and practices of terrorism as criminal and unjustifiable, wherever and by whomever committed, including those which jeopardize the friendly relations among states and peoples and threaten the territorial integrity and security of states. Noting United Nations General Assembly Resolution 51/210 of 17 December 1996 and the Declaration to supplement the 1994 Declaration on Measures to Eliminate International Terrorism annexed thereto. Recalling Resolutions 1368, 2001, and 1373, 2001, of the United Nations Security Council, which reflect international will to combat terrorism in all its forms and manifestations, and which assign tasks and responsibilities to states, and taking into account the continued threat from terrorist attacks. Recalling also Resolution 1540, 2004, of the United Nations Security Council, which recognizes the urgent need for all states to take additional effective measures to prevent the proliferation of nuclear, chemical or biological weapons and their means of delivery. Recalling further the Convention on Offenses and certain other acts committed on board aircraft, done at Tokyo on 14 September 1963, the Convention for the Suppression of Unlawful Seizure of Aircraft, done at The Hague on 16 December 1970, the Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation, done at Montreal on 23 September 1971, the Convention on the Prevention and Punishment of Crimes against Internationally Protected Persons, including diplomatic agents, adopted by the General Assembly of the United Nations on 14 December 1973, the International Convention Against the Taking of Hostages, adopted by the General Assembly of the United Nations on 17 December 1979, the Convention on the Physical Protection of Nuclear Material, done at Vienna on 26 October 1979 and amendments thereto adopted on 8 July 2005, the Protocol for the Suppression of Unlawful Acts of Violence at Airports Serving International Civil Aviation. Supplementary to the Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation, done at Montreal on 24 February 1988, the Protocol for the Suppression of Unlawful Acts against the Safety of Fixed Platforms located on the continental shelf, done at Rome on 10 March 1988, the Convention on the Marking of Plastic Explosives for the Purpose of Detection, done at Montreal on 1 March 1991, the International Convention for the Suppression of Terrorist Bombings, adopted by the General Assembly of the United Nations on 15 December 1997, the International Convention for the Suppression of the Financing of Terrorism, adopted by the General Assembly of the United Nations on 9 December 1999, and the International Convention for the Suppression of Acts of Nuclear Terrorism adopted by the General Assembly of the United Nations on 13 April 2005, bearing in mind the importance of the United Nations Convention on the Law of the Sea done at Montego Bay, on 10 December 1982, and of the customary international law of the sea, considering Resolution 5946 of the United Nations General Assembly, which reaffirmed that international cooperation as well as actions by states to combat terrorism should be conducted in conformity with the principles of the Charter of the United Nations, international law and relevant international conventions, and Resolution 5924 of the United Nations General Assembly, which urged states to become parties to the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation and its protocol, invited states to participate in the review of those instruments by the Legal Committee of the International Maritime Organization to strengthen the means of combating such unlawful acts, including terrorist acts, and also urged states to take appropriate measures to ensure the effective implementation of those instruments, in particular through the adoption of legislation, where appropriate, aimed at ensuring that there is a proper framework for responses to incidents of armed robbery and terrorist acts at sea. Considering also the importance of the amendments to the International Convention for the Safety of Life at Sea, 1974, and of the International Ship and Port Facility Security, ISPS, Code, both adopted by the 2002 Conference of Contracting Governments to that convention, in establishing an appropriate international technical framework involving cooperation between governments, government agencies, national and local administrations and the shipping and port industries to detect security threats and take preventative measures against security incidents affecting ships or port facilities used in international trade. Considering further Resolution 58/187 of the United Nations General Assembly, which reaffirmed that states must ensure that any measure taken to combat terrorism complies with their obligations under international law, in particular international human rights, refugee and humanitarian law. Believing that it is necessary to adopt provisions supplementary to those of the Convention, to suppress additional terrorist acts of violence against the safety and security of international maritime navigation and to improve its effectiveness, have agreed as follows. Article 1. For the purposes of this protocol. 1. Convention means the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, done at Rome on 10 March 1988. 2. Organization means the International Maritime Organization, IMO. 3. Secretary-General means the Secretary-General of the organization. Article 2. Article 1 of the Convention is amended to read as follows. Article 1, 1. For the purposes of this Convention, a ship means a vessel of any type whatsoever not permanently attached to the seabed, including dynamically supported craft, submersibles, or any other floating craft. b. Transport means to initiate, arrange or exercise effective control, including decision-making authority, over the movement of a person or item. c. Serious injury or damage means I. Serious bodily injury or 2. Extensive destruction of a place of public use, state or government facility, infrastructure facility, or public transportation system, resulting in major economic loss or 3. Substantial damage to the environment, including air, soil, water, fauna, or flora. d. BCN weapon means I. Biological weapons, which are 1. Microbial or other biological agents, or toxins whatever their origin or method of production, of types and in quantities that have no justification for prophylactic, protective or other peaceful purposes or 2. Weapons, equipment or means of delivery assigned to use such agents or toxins for hostile purposes or in armed conflict. 2. Chemical weapons, which are, together or separately, 1. Toxic chemicals and their precursors, except where intended for a. Industrial agricultural, research, medical, pharmaceutical or other peaceful purposes, or b. protective purposes, namely those purposes directly related to protection against toxic chemicals and to protection against chemical weapons, or c. military purposes not connected with the use of chemical weapons and not dependent on the use of the toxic properties of chemicals as a method of warfare, or d. law enforcement including domestic riot control purposes, as long as the types and quantities are consistent with such purposes. 2. Munitions and devices specifically designed to cause death or other harm through the toxic properties of those toxic chemicals specified in subparagraph 2(1), which would be released as a result of the employment of such munitions and devices. 3. Any equipment specifically designed for use directly in connection with the employment of munitions and devices specified in subparagraph 2(2). 3. Nuclear weapons and other nuclear explosive devices. Toxic chemical means any chemical which through its chemical action on life processes can cause death, temporary incapacitation or permanent harm to humans or animals. This includes all such chemicals, regardless of their origin or of their method of production, and regardless of whether they are produced in facilities, in munitions or elsewhere. Precursor means any chemical reactant which takes part at any stage in the production by whatever method of a toxic chemical. This includes any key component of a binary or multi-component chemical system. Organization means the International Maritime Organization, IMO. Secretary-General means the Secretary-General of the organization. 2. For the purposes of this convention. A. The terms place of public use, state or government facility, infrastructure facility, and public transportation system have the same meaning as given to those terms in the International Convention for the Suppression of Terrorist Bombings, done at New York on 15 December 1997. And b. The terms source material and special fissionable material have the same meaning as given to those terms in the Statute of the International Atomic Energy Agency, IAEA, done at New York on 26 October 1956. Article 3. The following text is added as Article 2 bis of the Convention. Article 2 bis. 1. Nothing in this convention shall affect other rights, obligations and responsibilities of states and individuals under international law, in particular the purposes and principles of the Charter of the United Nations and international human rights, refugee and humanitarian law. 2. This convention does not apply to the activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law, and the activities undertaken by military forces of a state in the exercise of their official duties, inasmuch as they are governed by other rules of international law. 3. Nothing in this convention shall affect the rights, obligations and responsibilities under the Treaty on the Non-Proliferation of Nuclear Weapons, done at Washington, London and Moscow on 1 July 1968, the Convention on the Prohibition of the Development, Production and Stockpiling of Bacteriological, Biological, and Toxin Weapons and on their Destruction, done at Washington, London and Moscow on 10 April 1972, or the Convention on the Prohibition of the Development, Production, Stockpiling and Use of Chemical Weapons and on their Destruction, done at Paris on 13 January 1993, of states parties to such treaties. Article 4, 1. The chap of Article 3, Paragraph 1 of the Convention is replaced by the following text: Any person commits an offense within the meaning of this convention if that person unlawfully and intentionally. 2. Article 3, Paragraph 1, f. of the Convention is replaced by the following text: f. communicates information which that person knows to be false, thereby endangering the safe navigation of a ship. 3. Article 3, Paragraph 1, g. of the Convention is deleted. 4. Article 3, Paragraph 2 of the Convention is replaced by the following text: 2. Any person also commits an offense if that person threatens, with or without a condition, as is provided for under national law, aimed at compelling a physical or juridical person to do or refrain from doing any act, to commit any of the offenses set forth in paragraphs 1, b, c, and e, if that threat is likely to endanger the safe navigation of the ship in question. 5. The following text is added as Article 3 bis of the Convention. Article 3 bis. 1. Any person commits an offense within the meaning of this convention if that person unlawfully and intentionally a. When the purpose of the act, by its nature or context, is to intimidate a population, or to compel a government or an international organization to do or to abstain from doing any act. I. Uses against or on a ship or discharges from a ship any explosive, radioactive material or BCN weapon in a manner that causes or is likely to cause death or serious injury or damage, or 2. Discharges, from a ship, oil, liquefied natural gas, or other hazardous or noxious substance, which is not covered by subparagraph a, I, in such quantity or concentration that causes or is likely to cause death or serious injury or damage, or 3. Uses a ship in a manner that causes death or serious injury or damage, or 4. Threatens, with or without a condition, as is provided for under national law, to commit an offense set forth in subparagraph a, I, 2, or 3, or b. Transports on board a ship I. Any explosive or radioactive material, knowing that it is intended to be used to cause, or in a threat to cause, with or without a condition, as is provided for under national law, death or serious injury or damage for the purpose of intimidating a population, or compelling a government or an international organization to do or to abstain from doing any act, or 2. Any BCN weapon, knowing it to be a BCN weapon as defined in Article 1, or 3. Any source material, special fissionable material, or equipment or material especially designed or prepared for the processing, use or production of special fissionable material, knowing that it is intended to be used in a nuclear explosive activity or in any other nuclear activity not under safeguards pursuant to an EAR Comprehensive Safeguards Agreement, or 4. Any equipment, materials or software or related technology that significantly contributes to the design, manufacture or delivery of a BCN weapon, with the intention that it will be used for such purpose. 2. It shall not be an offense within the meaning of this convention to transport an item or material covered by paragraph 1, b3, or, insofar as it relates to a nuclear weapon or other nuclear explosive device, paragraph 1, b4, if such item or material is transported to or from the territory of, or is otherwise transported under the control of, a state party to the Treaty on the Non-Proliferation of Nuclear Weapons where a. The resulting transfer or receipt, including internal to a state, of the item or material is not contrary to such state parties' obligations under the Treaty on the Non-Proliferation of Nuclear Weapons, and b. If the item or material is intended for the delivery system of a nuclear weapon or other nuclear explosive device of a state party to the Treaty on the Non-Proliferation of Nuclear Weapons, the holding of such weapon or device is not contrary to that state party's obligations under that treaty. 6. The following text is added as Article 3 ter of the Convention. Article 3 ter. Any person commits an offense within the meaning of this convention if that person unlawfully and intentionally transports another person on board a ship knowing that the person has committed an act that constitutes an offense set forth in Article 3, 3 bis or 3 quater, or an offense set forth in any treaty listed in the Annex, and intending to assist that person to evade criminal prosecution. The following text is added as Article 3 quater of the Convention. Article 3 quater. Any person also commits an offense within the meaning of this convention if that person a. Unlawfully and intentionally injures or kills any person in connection with the commission of any of the offenses set forth in Article 3, paragraph 1, Article 3 bis, or Article 3 ter or b. attempts to commit an offence set forth in Article 3, Paragraph 1, Article 3 bis, Paragraph 1, a, I, 2, or 3, or subparagraph a, of this article or c. participates as an accomplice in an offence set forth in Article 3, Article 3 bis, Article 3 ter, or subparagraph a, or b, of this article or d. organizes or directs others to commit an offence set forth in Article 3, Article 3 bis, Article 3 ter, or subparagraph a, or b, of this article or e. contributes to the commission of one or more offences set forth in Article 3, Article 3 bis, Article 3 ter or subparagraph a, or b, of this article, by a group of persons acting with a common purpose, intentionally and either I, with the aim of furthering the criminal activity or criminal purpose of the group, where such activity or purpose involves the commission of an offence set forth in Article 3, 3 bis or 3 ter or 2, in the knowledge of the intention of the group to commit an offence set forth in Article 3, 3 bis or 3 ter. Article 5, 1. Article 5 of the Convention is replaced by the following text: each state party shall make the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater punishable by appropriate penalties which take into account the grave nature of those offences. 2. The following text is added as Article 5 bis of the Convention, Article 5 bis, 1. Each state party, in accordance with its domestic legal principles, shall take the necessary measures to enable a legal entity located in its territory or organized under its laws to be held liable when a person responsible for management or control of the legal entity has, in that capacity, committed an offense set forth in this convention. Such liability may be criminal, civil or administrative. 2. Such liability is incurred without prejudice to the criminal liability of individuals having committed the offences. 3. Each state party shall ensure, in particular, that legal entities liable in accordance with Paragraph 1 are subject to effective, proportionate and dissuasive criminal, civil or administrative sanctions. Such sanctions may include monetary sanctions. Article 6. 1. The chap of Article 6, Paragraph 1 of the Convention is replaced by the following text. 1. Each state party shall take such measures as may be necessary to establish its jurisdiction over the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater when the offence is committed. 2. Article 6, Paragraph 3 of the Convention is replaced by the following text. 3. Any state party which has established jurisdiction mentioned in Paragraph 2 shall notify the Secretary-General. If such state party subsequently rescinds that jurisdiction, it shall notify the Secretary-General. 3. Article 6, Paragraph 4 of the Convention is replaced by the following text. 4. Each state party shall take such measures as may be necessary to establish its jurisdiction over the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater in cases where the alleged offender is present in its territory and it does not extradite the alleged offender to any of the states parties which have established their jurisdiction in accordance with Paragraphs 1 and 2 of this article. Article 7. The following text is added as the Annex to the Convention, Annex 1. Convention for the Suppression of Unlawful Seizure of Aircraft, done at The Hague on 16 December 1970. 2. Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation, done at Montreal on 23 September 1971. 3. Convention on the Prevention and Punishment of Crimes against Internationally Protected Persons, including diplomatic agents, adopted by the General Assembly of the United Nations on 14 December 1973. 4. International Convention against the Taking of Hostages, adopted by the General Assembly of the United Nations on 17 December 1979. 5. Convention on the Physical Protection of Nuclear Material, done at Vienna on the 26th of October 1979. 6. Protocol for the Suppression of Unlawful Acts of Violence at Airports Serving International Civil Aviation, supplementary to the Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, done at Montreal on the 24th of February 1988. 7. Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platforms located on the Continental Shelf, done at Rome on the 10th of March 1988. 8. International Convention for the Suppression of Terrorist Bombings, adopted by the General Assembly of the United Nations on the 15th of December 1997. 9. International Convention for the Suppression of the Financing of Terrorism, adopted by the General Assembly of the United Nations on the 9th of December 1999. Article 8, 1. Article 8, Paragraph 1 of the Convention is replaced by the following text: 1. The master of a ship of a state party, the flag state, may deliver to the authorities of any other state party, the receiving state, any person who the master has reasonable grounds to believe has committed an offense set forth in Article 3, 3 bis, 3 ter, or 3 quater. 2. The following text is added as Article 8 bis of the Convention. Article 8 bis, 1. States parties shall cooperate to the fullest extent possible to prevent and suppress unlawful acts covered by this convention, in conformity with international law, and shall respond to requests pursuant to this article as expeditiously as possible. 2. Each request pursuant to this article should, if possible, contain the name of the suspect ship, the IMO ship identification number, the port of registry, the ports of origin and destination, and any other relevant information. If a request is conveyed orally, the requesting party shall confirm the request in writing as soon as possible. The requested party shall acknowledge its receipt of any written or oral request immediately. 3. States parties shall take into account the dangers and difficulties involved in boarding a ship at sea and searching its cargo, and give consideration to whether other appropriate measures agreed between the states concerned could be more safely taken in the next port of call or elsewhere. 4. A state party that has reasonable grounds to suspect that an offense set forth in Article 3, 3 bis, 3 ter or 3 quater has been, is being or is about to be committed involving a ship flying its flag, may request the assistance of other states parties in preventing or suppressing that offense. The states parties so requested shall use their best endeavors to render such assistance within the means available to them. 5. Whenever law enforcement or other authorized officials of a state party, the requesting party, encounter a ship flying the flag or displaying marks of registry of another state party, the first party, located seaward of any state's territorial sea, and the requesting party has reasonable grounds to suspect that the ship or a person on board the ship has been, is or is about to be involved in the commission of an offense set forth in Article 3, 3 bis, 3 ter or 3 quater, and the requesting party desires to board. A. It shall request, in accordance with paragraphs 1 and 2, that the first party confirm the claim of nationality, and b. If nationality is confirmed, the requesting party shall ask the first party, hereinafter referred to as the flag state, for authorization to board and to take appropriate measures with regard to that ship, which may include stopping, boarding and searching the ship, its cargo and persons on board, and questioning the persons on board in order to determine if an offense set forth in Article 3, 3 bis, 3 ter or 3 quater has been, is being or is about to be committed, and c. The flag state shall either I. Authorize the requesting party to board and to take appropriate measures set out in subparagraph b, subject to any conditions it may impose in accordance with paragraph 7, or 2. Conduct the boarding and search with its own law enforcement or other officials, or 3. Conduct the boarding and search together with the requesting party, subject to any conditions it may impose in accordance with paragraph 7, or 4. Decline to authorize a boarding and search. The requesting party shall not board the ship or take measures set out in subparagraph B, without the express authorization of the flag state. D. Upon or after depositing its instrument of ratification, acceptance, approval or accession, a state party may notify the Secretary-General that, with respect to ships flying its flag or displaying its mark of registry, the requesting party is granted authorization to board and search the ship, its cargo and persons on board, and to question the persons on board in order to locate and examine documentation of its nationality and determine if an offense set forth in Article 3, 3 bis, 3 ter or 3 quater has been, is being or is about to be committed, if there is no response from the first party within 4 hours of acknowledgement of receipt of a request to confirm nationality. E. Upon or after depositing its instrument of ratification, acceptance, approval or accession, a state party may notify the Secretary-General that, with respect to ships flying its flag or displaying its mark of registry, the requesting party is authorized to board and search a ship, its cargo and persons on board, and to question the persons on board in order to determine if an offense set forth in Article 3, 3 bis, 3 ter or 3 quater has been, is being or is about to be committed. The notifications made pursuant to this paragraph can be withdrawn at any time. 6. When evidence of conduct described in Article 3, 3 bis, 3 ter or 3 quater is found as the result of any boarding conducted pursuant to this article, the flag state may authorize the requesting party to detain the ship, cargo and persons on board pending receipt of disposition instructions from the flag state. The requesting party shall promptly inform the flag state of the results of a boarding, search, and detention conducted pursuant to this article. The requesting party shall also promptly inform the flag state of the discovery of evidence of illegal conduct that is not subject to this convention. 7. The flag state, consistent with the other provisions of this convention, may subject its authorization under paragraph 5 or 6 to conditions, including obtaining additional information from the requesting party, and conditions relating to responsibility for and the extent of measures to be taken. No additional measures may be taken without the express authorization of the flag state, except when necessary to relieve imminent danger to the lives of persons or where those measures derive from relevant bilateral or multilateral agreements. 8. For all boardings pursuant to this article, the flag state has the right to exercise jurisdiction over a detained ship, cargo or other items and persons on board, including seizure, forfeiture, arrest and prosecution. However, the flag state may, subject to its constitution and laws, consent to the exercise of jurisdiction by another state having jurisdiction under Article 6. 9. When carrying out the authorized actions under this article, the use of force shall be avoided except when necessary to ensure the safety of its officials and persons on board, or where the officials are obstructed in the execution of the authorized actions. Any use of force pursuant to this article shall not exceed the minimum degree of force which is necessary and reasonable in the circumstances. 10. Safeguards. A. Where a state party takes measures against a ship in accordance with this article, it shall I. Take due account of the need not to endanger the safety of life at sea. 2. Ensure that all persons on board are treated in a manner which preserves their basic human dignity, and in compliance with the applicable provisions of international law, including international human rights law. 3. Ensure that a boarding and search pursuant to this article shall be conducted in accordance with applicable international law. 4. Take due account of the safety and security of the ship and its cargo. V. Take due account of the need not to prejudice the commercial or legal interests of the flag state. Vi. Ensure, within available means, that any measure taken with regard to the ship or its cargo is environmentally sound under the circumstances. 7. Ensure that persons on board against whom proceedings may be commenced in connection with any of the offences set forth in Article 3, 3 bis. 3 ter or 3 quater are afforded the protections of paragraph 2 of Article 10, regardless of location. 8. Ensure that the master of a ship is advised of its intention to board, and is, or has been, afforded the opportunity to contact the ship's owner and the flag state at the earliest opportunity, and 9. Take reasonable efforts to avoid a ship being unduly detained or delayed. b. Provided that authorization to board by a flag state shall not per se give rise to its liability, states parties shall be liable for any damage, harm or loss attributable to them arising from measures taken pursuant to this article when I. The grounds for such measures prove to be unfounded, provided that the ship has not committed any act justifying the measures taken, or 2. Such measures are unlawful or exceed those reasonably required in light of available information to implement the provisions of this article. States parties shall provide effective recourse in respect of such damage, harm or loss. c. Where a state party takes measures against a ship in accordance with this convention, it shall take due account of the need not to interfere with or to affect I. The rights and obligations and the exercise of jurisdiction of coastal states in accordance with the international law of the sea, or 2. The authority of the flag state to exercise jurisdiction and control in administrative, technical and social matters involving the ship. d. Any measure taken pursuant to this article shall be carried out by law enforcement or other authorized officials from warships or military aircraft, or from other ships or aircraft clearly marked and identifiable as being on government service and authorized to that effect, and, notwithstanding Articles 2 and 2 bis, the provisions of this article shall apply. e. For the purposes of this article, law enforcement or other authorized officials means uniformed or otherwise clearly identifiable members of law enforcement or other government authorities duly authorized by their government. For the specific purpose of law enforcement under this convention, law enforcement or other authorized officials shall provide appropriate government-issued identification documents for examination by the master of the ship upon boarding. 11. This article does not apply to or limit boarding of ships conducted by any state party in accordance with international law, seaward of any state's territorial sea, including boardings based upon the right of visit, the rendering of assistance to persons, ships and property in distress or peril, or an authorization from the flag state to take law enforcement or other action. 12. States parties are encouraged to develop standard operating procedures for joint operations pursuant to this article and consult, as appropriate, with other states parties with a view to harmonizing such standard operating procedures for the conduct of operations. 13. States parties may conclude agreements or arrangements between them to facilitate law enforcement operations carried out in accordance with this article. 14. Each state party shall take appropriate measures to ensure that its law enforcement or other authorized officials, and law enforcement or other authorized officials of other states parties acting on its behalf, are empowered to act pursuant to this article. 15. Upon or after depositing its instrument of ratification, acceptance, approval or accession, each state party shall designate the authority, or, where necessary, authorities to receive and respond to requests for assistance, for confirmation of nationality, and for authorization to take appropriate measures. Such designation, including contact information, shall be notified to the Secretary-General within 1 month of becoming a party, who shall inform all other states parties within 1 month of the designation. Each state party is responsible for providing prompt notice through the Secretary-General of any changes in the designation or contact information. Article 9, Article 10, Paragraph 2 is replaced by the following text: 2. Any person who is taken into custody, or regarding whom any other measures are taken or proceedings are being carried out pursuant to this convention, shall be guaranteed fair treatment, including enjoyment of all rights and guarantees in conformity with the law of the state in the territory of which that person is present and applicable provisions of international law, including international human rights law. Article 10, 1. Article 11, paragraphs 1, 2, 3 and 4 are replaced by the following text. 1. The offences set forth in Articles 3, 3 bis, 3 ter and 3 quater shall be deemed to be included as extraditable offences in any extradition treaty existing between any of the states parties. States parties undertake to include such offences as extraditable offences in every extradition treaty to be concluded between them. 2. If a state party which makes extradition conditional on the existence of a treaty receives a request for extradition from another state party with which it has no extradition treaty, the requested state party may, at its option, consider this convention as a legal basis for extradition in respect of the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater. Extradition shall be subject to the other conditions provided by the law of the requested state party. 3. States parties which do not make extradition conditional on the existence of a treaty shall recognize the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater as extraditable offences between themselves, subject to the conditions provided by the law of the requested state party. 4. If necessary, the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater shall be treated, for the purposes of extradition between states parties, as if they had been committed not only in the place in which they occurred but also in a place within the jurisdiction of the state party requesting extradition. 2. The following text is added as Article 11 bis, of the Convention. Article 11 bis, none of the offences set forth in Article 3, 3 bis, 3 ter or 3 quater shall be regarded for the purposes of extradition or mutual legal assistance as a political offence or as an offence connected with a political offence or as an offence inspired by political motives. Accordingly, a request for extradition or for mutual legal assistance based on such an offence may not be refused on the sole ground that it concerns a political offence or an offence connected with a political offence or an offence inspired by political motives. 3. The following text is added as Article 11 ter of the Convention. Article 11 ter, nothing in this convention shall be interpreted as imposing an obligation to extradite or to afford mutual legal assistance, if the requested state party has substantial grounds for believing that the request for extradition for offences set forth in Article 3, 3 bis, 3 ter or 3 quater or for mutual legal assistance with respect to such offences has been made for the purpose of prosecuting or punishing a person on account of that person's race, religion, nationality, ethnic origin, political opinion or gender, or that compliance with the request would cause prejudice to that person's position for any of these reasons. Article 11, 1. Article 12. Paragraph 1 of the Convention is replaced by the following text. 1. States parties shall afford one another the greatest measure of assistance in connection with criminal proceedings brought in respect of the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater, including assistance in obtaining evidence at their disposal necessary for the proceedings. 2. The following text is added as Article 12 bis of the Convention. Article 12 bis. 1. A person who is being detained or is serving a sentence in the territory of one state party whose presence in another state party is requested for purposes of identification, testimony or otherwise providing assistance in obtaining evidence for the investigation or prosecution of offences set forth in Article 3, 3 bis, 3 ter or 3 quater may be transferred if the following conditions are met. A. The person freely gives informed consent and b. The competent authorities of both states agree, subject to such conditions as those states may deem appropriate. 2. For the purposes of this article, a. The state to which the person is transferred shall have the authority and obligation to keep the person transferred in custody, unless otherwise requested or authorized by the state from which the person was transferred. b. The state to which the person is transferred shall without delay implement its obligation to return the person to the custody of the state from which the person was transferred as agreed beforehand, or as otherwise agreed, by the competent authorities of both states. C. The state to which the person is transferred shall not require the state from which the person was transferred to initiate extradition proceedings for the return of the person. D. The person transferred shall receive credit for service of the sentence being served in the state from which the person was transferred for time spent in the custody of the state to which the person was transferred. 3. Unless the state party from which a person is to be transferred in accordance with this article so agrees, that person, whatever that person's nationality, shall not be prosecuted or detained or subjected to any other restriction of personal liberty in the territory of the state to which that person is transferred in respect of acts or convictions anterior to that person's departure from the territory of the state from which such person was transferred. Article 12. Article 13 of the Convention is replaced by the following text. 1. States parties shall cooperate in the prevention of the offences set forth in Articles 3, 3 bis, 3 ter and 3 quater, particularly by a. Taking all practicable measures to prevent preparation in their respective territories for the commission of those offences within or outside their territories. b. Exchanging information in accordance with their national law, and coordinating administrative and other measures taken as appropriate to prevent the commission of offences set forth in Articles 3, 3 bis, 3 ter and 3 quater. 2. When, due to the commission of an offence set forth in Article 3, 3 bis, 3 ter or 3 quater, the passage of a ship has been delayed or interrupted, any state party in whose territory the ship or passengers or crew are present shall be bound to exercise all possible efforts to avoid the ship, its passengers, crew or cargo being unduly detained or delayed. Article 13. Article 14 of the Convention is replaced by the following text. Any state party having reason to believe that an offence set forth in Article 3, 3 bis, 3 ter or 3 quater will be committed shall, in accordance with its national law, furnish as promptly as possible any relevant information in its possession to those states which it believes would be the states having established jurisdiction in accordance with Article 6. Article 14. Article 15, paragraph 3 of the Convention is replaced by the following text. 3. The information transmitted in accordance with paragraphs 1 and 2 shall be communicated by the Secretary-General to all states parties, to members of the organization, to other states concerned, and to the appropriate international intergovernmental organizations. Interpretation and application. Article 15, 1. The Convention and this Protocol shall, as between the parties to this Protocol, be read and interpreted together as one single instrument. 2. Articles 1 to 16 of the Convention, as revised by this Protocol, together with Articles 17 to 24 of this Protocol and the Annex thereto, shall constitute and be called the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, 2005, 2005 SWAC Convention. Article 16. The following text is added as Article 16 bis of the Convention. Final clauses of the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, 2005. The final clauses of the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, 2005 shall be Articles 17 to 24 of the Protocol of 2005 to the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation. References in this convention to states parties shall be taken to mean references to states parties to that protocol. Final clauses. Article 17, Signature, Ratification, Acceptance, Approval and Accession 1. This protocol shall be open for signature at the headquarters of the organization from the 14th of February 2006 to the 13th of February 2007 and shall thereafter remain open for accession. 2. States may express their consent to be bound by this protocol by a. Signature without reservation as to ratification, acceptance or approval, or b. Signature subject to ratification, acceptance or approval, followed by ratification, acceptance or approval, or c. Accession. 3. Ratification, acceptance, approval or accession shall be effected by the deposit of an instrument to that effect with the Secretary-General. 4. Only a state which has signed the convention without reservation as to ratification, acceptance or approval, or has ratified, accepted, approved or acceded to the convention may become a party to this protocol. Entry into force, Article 18, 1. This protocol shall enter into force 90 days following the date on which 12 states have either signed it without reservation as to ratification, acceptance or approval, or have deposited an instrument of ratification, acceptance, approval or accession with the Secretary-General. 2. For a state which deposits an instrument of ratification, acceptance, approval or accession in respect of this protocol after the conditions in paragraph 1 for entry into force thereof have been met, the ratification, acceptance, approval or accession shall take effect 90 days after the date of such deposit. Denunciation, Article 19, 1. This protocol may be denounced by any state party at any time after the date on which this protocol enters into force for that state. 2. Denunciation shall be effected by the deposit of an instrument of denunciation with the Secretary-General. 3. A denunciation shall take effect 1 year, or such longer period as may be specified in the instrument of denunciation, after the deposit of the instrument with the Secretary-General. Revision and Amendment, Article 20, 1. A conference for the purpose of revising or amending this protocol may be convened by the organization. 2. The Secretary-General shall convene a conference of states parties to this protocol for revising or amending the protocol, at the request of 1/3 of the states parties, or 10 states parties, whichever is the higher figure. 3. Any instrument of ratification, acceptance, approval or accession deposited after the date of entry into force of an amendment to this protocol shall be deemed to apply to the protocol as amended. Declarations, Article 21, 1. Upon depositing its instrument of ratification, acceptance, approval or accession, a state party which is not a party to a treaty listed in the Annex may declare that, in the application of this protocol to the state party, the treaty shall be deemed not to be included in Article 3 ter. The declaration shall cease to have effect as soon as the treaty enters into force for the state party, which shall notify the Secretary-General of this fact. 2. When a state party ceases to be a party to a treaty listed in the Annex, it may make a declaration as provided for in this article, with respect to that treaty. 3. Upon depositing its instrument of ratification, acceptance, approval or accession, a state party may declare that it will apply the provisions of Article 3 ter in accordance with the principles of its criminal law concerning family exemptions of liability. Amendments to the Annex. Article 22. 1. The Annex may be amended by the addition of relevant treaties that a. are open to the participation of all states, b. have entered into force and c. have been ratified, accepted, approved or acceded to by at least 12 states parties to this protocol. 2. After the entry into force of this protocol, any state party thereto may propose such an amendment to the Annex. Any proposal for an amendment shall be communicated to the Secretary-General in written form. The Secretary-General shall circulate any proposed amendment that meets the requirements of paragraph 1 to all members of the organization and seek from states parties to this protocol their consent to the adoption of the proposed amendment. 3. The proposed amendment to the Annex shall be deemed adopted after more than 12 of the states parties to this protocol consent to it by written notification to the Secretary-General. 4. The adopted amendment to the Annex shall enter into force 30 days after the deposit with the Secretary-General of the 12th instrument of ratification, acceptance or approval of such amendment for those states parties to this protocol that have deposited such an instrument. For each state party to this protocol ratifying, accepting or approving the amendment after the deposit of the 12th instrument with the Secretary-General, The amendment shall enter into force on the 30th day after deposit by such state party of its instrument of ratification, acceptance or approval. Depository, Article 23, 1. This protocol and any amendments adopted under Articles 20 and 22 shall be deposited with the Secretary-General. 2. The Secretary-General shall a. Inform all states which have signed this protocol or acceded to this protocol of I. Each new signature or deposit of an instrument of ratification, acceptance, approval or accession together with the date thereof. 2. The date of the entry into force of this protocol. 3. The deposit of any instrument of denunciation of this protocol together with the date on which it is received and the date on which the denunciation takes effect. 4. Any communication called for by any article of this protocol. v. Any proposal to amend the annex which has been made in accordance with Article 22, Paragraph 2. vi. Any amendment deemed to have been adopted in accordance with Article 22, Paragraph 3. 7. Any amendment ratified, accepted or approved in accordance with Article 22, Paragraph 4. Together with the date on which that amendment shall enter into force and b. Transmit certified true copies of this protocol to all states which have signed or acceded to this protocol. 3. As soon as this protocol enters into force, a certified true copy of the text shall be transmitted by the Secretary-General to the Secretary-General of the United Nations for registration and publication in accordance with Article 102 of the Charter of the United Nations. Languages, Article 24. This protocol is established in a single original in the Arabic, Chinese, English, French, Russian and Spanish languages, each text being equally authentic. Done at London this 14th day of October 2005. In witness whereof the undersigned, being duly authorized by their respective governments for that purpose, have signed this protocol.